Here's a live look at the Whipple Federal Building near Fort Snelling, where people have been protesting nearly nonstop since an ICE agent shot and killed Renee Good 9 days ago. ICE arrested 4 people here yesterday. Agents claimed they threw objects, swore at agents, and poured water on the roads to create icy conditions. New tonight, a federal judge ruled federal agents cannot detain or use tear gas on peaceful protesters.
A federal judge just handed ICE a major loss, and then Trump's administration immediately exposed their own lie about it. Let me break this down for you, because the contradiction here is perfect. Friday, January 17th, U.S. District Judge Katherine Menendez issues an 82-page ruling in Minnesota. It's a preliminary injunction, and it's sweeping. The judge orders ICE agents to stop tear gassing peaceful protesters, stop arresting people for observing their operations, stop using pepper spray on people who are just documenting what's happening, stop pulling over vehicles just because someone's following them at a safe distance. This is an ACLU victory. They brought this case on behalf of 6 activists who said federal agents violated their First and Fourth Amendment rights. And the judge agreed, found a pattern of constitutional violations. 82 pages of findings backing up what protesters have been saying all along. Judge Menendez found that chemical agents had been used against protesters on at least 4 occasions, that federal agents had stopped vehicles without citing any violation of traffic law, that people engaged in peaceful observation were subjected to retaliation. The order is specific. ICE can't arrest or detain people engaged in peaceful protest, can't use tear gas or pepper spray against peaceful protesters or people observing operations, can't stop vehicles without reasonable suspicion, can't retaliate against people for exercising their First Amendment rights. This is exactly what protesters needed: real protection. A federal judge saying you have the right to observe police, to document what federal agents are doing, to peacefully protest without getting tear gassed or arrested for it. The order stays in effect until Operation Metro Surge ends or conditions change. That's the big 3,000-agent operation ICE has been running in Minneapolis, the largest in Department of Homeland Security history. So that's the Friday victory. ACLU wins. Judge blocks ICE from using these tactics. Constitutional rights protected. Then Sunday happens. DHS Secretary Kristi Noem goes on CBS's Face the Nation, and she says something remarkable. She calls the judge's order ridiculous. Why? Because according to Noem, the judge told them they couldn't do what they already weren't doing. Let me read you her full statement. She said, quote, "We only use those chemical agents when there's violence happening and perpetuating. And you need to be able to establish law and order to keep people safe." So that judge's order didn't change anything for how we're operating on the ground, because it's basically telling us to do what we've already been doing. End quote. Got that? Known saying we're already following these rules. We already don't use tear gas on peaceful protesters. We already don't arrest people without cause. The judge's order changes nothing because we were already doing this. If that's true, why would the order be a problem? Why call it ridiculous if you're already complying? Host Margaret Brennan immediately caught this. She confronted Noem with video evidence. She said, quote, "But we just saw video of chemical agents being used," end quote. And Noem shifted. Suddenly it became, well, we only use them when there's violence. Not we don't use them. We only use them when justified. That's Sunday. Noem on national TV claiming ICE is already following the rules the judge ordered them to follow. Monday, yesterday, January 20th, Martin Luther King Jr. Day. The Department of Justice files a notice of appeal. They're asking the 8th Circuit Court of Appeals to overturn Judge Menendez's ruling. They want those restrictions lifted. Think about that. Sunday, the DHS Secretary says the order doesn't change anything because we're already doing this. Monday, the DOJ appeals to overturn the order. I'm telling you, this contradiction is so blatant, it's almost funny. If you're already following the rules, why would you appeal an order requiring you to follow them? The appeal directly contradicts Noem's claim. You don't fight to overturn restrictions you claim you're already complying with. The only reason to appeal is because the appeal seeks to preserve the discretion to do the things the judge said they can't do. The appeal would allow using tear gas on peaceful protesters, would allow arresting people for observing, would allow stopping vehicles without reasonable suspicion. The appeal reveals what they actually want, and it directly contradicts what Noem said on Sunday. Look, if ICE was really only using chemical agents against violent protesters, like Noem claimed, the order wouldn't restrict them. Because the order specifically says peaceful protesters. If protesters are violent, they're not peaceful. ICE could still respond to actual violence, but they're appealing anyway. The appeal suggests they seek the discretion to use tear gas on people who aren't violent, on people who are peacefully observing, on bystanders, on journalists, on anyone they decide is inconvenient. Let me tell you what Judge Menendez actually found, because the government tried to claim these were isolated incidents. The judge looked at the evidence and said, no, this is a pattern. Chemical agents used on at least 4 occasions against protesters. Multiple people stopped by federal agents who didn't cite any traffic violation. People subjected to retaliation for exercising their First Amendment rights. The judge wasn't making this up. She had testimony. She had evidence. 82 pages of detailed findings. And she explicitly said the government failed to explain why it's necessary to arrest and use force against peaceful observers. You know what the DOJ didn't submit? Police reports, body camera footage, statements from ICE agents involved in these incidents. The judge asked for this evidence. DOJ attorney Jeremy Newman said they were responding over the holidays and did the best they could. The judge was clearly frustrated with that excuse. Because if your position is that ICE agents acted appropriately, you'd want to show the evidence proving that. You'd want the body camera footage showing protesters being violent. You'd want the police reports documenting the threats. But they didn't provide any of that. What DOJ did argue is even more revealing. Attorney Jeremy Newman told the judge there is no constitutional right to observe police activity. He said mere observation doesn't trigger First Amendment protection. Think about what that means. The Justice Department is arguing you don't have a constitutional right to watch police doing their jobs. That filming federal agents isn't protected speech. That if you're peacefully standing nearby documenting what's happening, they can arrest you for it. Judge Menendez rejected that authoritarian position. She ruled that peaceful observation of law enforcement can be protected First Amendment activity when it functions as expressive conduct. She said people have the right to document federal operations, and now DOJ is appealing that ruling. They're fighting to establish that you don't have the right to record police, that observing federal agents is something they can arrest you for. This isn't abstract legal theory. This is about real people. The case was brought by 6 activists. One of them is Abdi Kadir Noor, a Somali-American U.S. citizen. They alleged federal agents subjected them to chemical irritants, pointed firearms at them, detained them, arrested them, for observing, for documenting, for exercising their First Amendment rights. And they won. Judge Menendez agreed with them, said yes, your rights were violated, issued an injunction protecting those rights going forward. That's a victory worth celebrating. The ACLU of Minnesota did this. They took the case. They presented the evidence. They won constitutional protections for thousands of people who want to peacefully observe and document what federal agents are doing in their communities. But the victory is already under threat. The appeal could suspend the injunction while the case works through the courts, or it could overturn the ruling entirely. There's precedent for that. Last year in Illinois, a federal judge issued a similar injunction limiting ICE tactics. An appellate court blocked it, calling it too broad and too prescriptive. Judge Menendez seems to have learned from that. Her ruling is more targeted. She explicitly stated the injunction does nothing to prevent defendants from continuing to enforce immigration laws. ICE can still make arrests. They can still conduct operations. They just have to respect constitutional rights while doing it. She left room for enforcement actions where there's specific evidence of interference. She made clear distinctions between constitutional rights to observe and actual obstruction. This is a narrower, more carefully crafted ruling than the Illinois case. But DOJ is still appealing. The appeal seeks to remove even these narrow restrictions. The effect would be to restore broad discretion to use whatever tactics they choose against anyone observing them. The Eighth Circuit will now decide whether to grant a stay of the injunction, which would suspend it during the appeal, or they could let it remain in effect while they consider the case. Eventually, they'll rule on whether the injunction was proper. I'm telling you, this matters, because what Judge Menendez protected is fundamental. The right to observe police, the right to document what government agents are doing, the right to peacefully protest without getting tear-gassed for it. If DOJ wins this appeal, they're establishing that federal agents can arrest you for watching them, can tear-gas you for standing nearby, can pull you over for following them at a safe distance while obeying all traffic laws. That's not law enforcement. That's suppression of oversight. That's making it impossible for citizens to hold federal agents accountable. And the contradiction between what Noem said Sunday and what DOJ did Monday proves they know it. They can't admit they want to keep violating constitutional rights. So Noem goes on TV and claims they're already following the rules. Then DOJ immediately files an appeal to overturn those rules. It's the same pattern we keep seeing. Officials claiming they're acting appropriately while simultaneously fighting to avoid any restrictions on their conduct. Say we're already doing this while appealing orders that would require them to actually do it. The lie is right there in the timeline. Sunday claim, Monday appeal. Can't both be true. Either you're already following these rules, in which case the order changes nothing and there's no reason to appeal, or you're not following them. You want to keep not following them, and the appeal is your attempt to preserve the freedom to violate rights. The appeal chose the second option. They want to keep doing what the judge said they can't do. Judge Menendez's ruling explicitly addressed the government's main arguments. DOJ claims that following ICE agents creates danger, that this climate of following leads to dangerous activity. The judge said no. She ruled that safely following officers at an appropriate distance does not, by itself, create reasonable suspicion to justify a vehicle stop. That is the controlling order right now in Minnesota. You can follow federal agents at a safe distance while obeying traffic laws. They can't stop you just for observing them. They need reasonable suspicion of an actual violation. And DOJ is appealing that because they want to be able to stop anyone following them, want to be able to intimidate observers, want to make it risky to document what they're doing. This is what accountability looks like when it works. Citizens exercise their rights, document misconduct, bring a lawsuit. A judge reviews the evidence and sides with the citizens, issues an order protecting constitutional rights. And this is what it looks like when authoritarians fight back. They claim they're already following the law. Then they appeal to avoid having to follow it. They argue there's no constitutional right to observe police. They fight to preserve their ability to use force against peaceful people exercising their rights. The ACLU won this round. That's real. That's a victory. Judge Menendez issued a strong, well-reasoned ruling protecting First and Fourth Amendment rights. People in Minnesota have concrete protections right now that they didn't have last week. But the fight isn't over. The appeal could take those protections away. The Eighth Circuit could side with DOJ, could say judges shouldn't micromanage law enforcement tactics, could decide that ICE needs the flexibility to use tear gas and make arrests at their discretion. That's why this contradiction matters. That's why Noem's Sunday claim, followed by Monday's appeal, is so devastating. It proves they're not operating in good faith. They're not trying to balance rights with enforcement. They're fighting to avoid any meaningful restrictions on their power. If they were really already following these rules, like Noem said, they'd welcome the judge's order. They'd say, "Great, you're codifying what we're already doing, no problem." But they didn't. They appealed because Noem lied. I'm telling you, pay attention to this case. Tincher versus Noem. Remember that name. Because what happens here will determine whether people have the right to observe and document federal law enforcement in their communities, whether you can peacefully protest without getting tear gassed, whether journalists can follow police without getting arrested. Judge Menendez said, yes, you have those rights. The ACLU proved those rights were being violated and won protections. Now we have to defend that victory. Because Trump's DOJ is coming for it. They filed the appeal yesterday, Monday, January 19th. They're fighting to take these protections away. And the contrast between Sunday's lie and Monday's appeal shows exactly why they need to be stopped. Here's what I want you to take from this. First, celebrate the win. The ACLU did something real here. They protected constitutional rights. They got a federal judge to rule that yes, ICE was violating rights, and yes, that has to stop. That matters. That's organizing and legal action achieving concrete results. Second, understand the lie. When Noem says we're already doing this, then DOJ appeals the next day, that's not a miscommunication. That's not different agencies with different priorities. That's a coordinated attempt to have it both ways. Claim compliance in public while fighting restrictions in court. Third, recognize what's at stake. This isn't just about Minnesota. This is about whether federal agents anywhere can arrest you for filming them, whether they can tear gas you for standing nearby, whether they can pull you over for the crime of observing them do their jobs. DOJ's position is that you have no constitutional right to watch police. That observation isn't protected speech. That agents can use force to stop you from documenting their actions. If they win this appeal, that becomes precedent. That becomes the law. And finally, stay on this. The Eighth Circuit will rule. Could be weeks, could be months. When they do, it'll matter. If they uphold Judge Menendez, constitutional protections get stronger. If they overturn her, federal agents get a green light to suppress oversight. Right now, today, people in Minnesota have real protections they didn't have a week ago. ICE can't tear gas them for protesting, can't arrest them for observing, can't stop their cars for following at a safe distance. That's a win. Enjoy it, defend it. Don't let them take it away without a fight.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.